I was particularly interested in the argument for the proposition that constitutional ontology is not jurisprudence. And at this exact moment, you have me convinced. Okay, and so my constructive suggestion has to do then with the shift to part 7 and the way forward, where I suddenly felt a bit disoriented because you made a set of very lightly sketched out suggestions that in fact do depend on some general jurisprudential commitments. And I think just a bit more framing for those of us who might not be familiar with your entire body of work could be really helpful in that section, because some of those seem to depend on some Hardian premises. Some seem to trade on some, consequentialist or even legal realist ideas. And so adding a bit more clarity and specificity to sort of where those are normatively motivated, I thought would have strengthened the ending of the paper.
If the title of the paper is not yet fully fixed, I would nominate just shortening it to What Our Constitution Is, which I think is the topic of the paper, rather than making it derivative of Sunstein, but I'll ask my question. So I think I love the paper. It's an important topic. GNAP is an important challenger, and most importantly, I think the paper tells me what I want to hear and flatters my preconceptions, which is great. But I want to double check whether it tells me everything I need to hear or whether or not I still need to do more to get what I need. So if I take a fairly Harshan sort of social facts view about what law is, and think that, then I want to know, I'd like to believe that our law, as the founders' law, is lawfully changed, and that in 1789, the Constitution was our law under kind of Harshan criteria of legal validity. There was enough agreement to create a social rule that proved that the Constitution was law in the sense we're talking about. I take GNAP's challenge to be that was just not, as a matter of fact, there was not enough agreement to mark a real social rule of the legal status of the Constitution in 1789. That didn't happen until later. And that would be really unfortunate for me if it were true, although I'll deal with it, of course. So my question is, have you done enough to show that that's not true? Have you done enough to show that there was not sufficiently widespread disagreement with the nature of the Constitution to sort of deny its legal status in Harshan terms? I mean, maybe I'll live with it. Maybe it'll turn out that as a technical matter, the legal founding of the Constitution didn't happen until 1801, at which point our legal rules caught up to recognize the status of the Constitution or something. But that's what I'd like to know is, have you done enough, or do I still need to do it? Third question.
Lee? The trilogy.
Evidence about what this Constitution is. It fits in your pocket. And is that the extent of the evidence? Is there a reason why you don't survey other evidence, don't look to other places like the executive branch's practice? So that's my first comment. Second, on the list, beginning on page 43, some of the items in the list seem to fit in what I would think would be an ontology of the Constitution, but one of them didn't seem to. So the Civil War was one that I wasn't sure about. It's obviously true that it's important, but it wasn't clear from the argument that you all make that the Civil War is important as opposed to the Reconstruction Amendments. You also talk about one of the commitments is that this is the oldest operating written Constitution, which isn't true, right? Massachusetts is older, and I also don't know why the oldest one would matter to your ontology. And then if the Civil War is in there, why are other very, very important constitutional moments not in there? So progressive era amendments, the New Deal precedential amendments and things like that. My third comment is, I was wondering in your discussion about different perspectives of law and what the Constitution is, and whether or not, from a natural lawyer's perspective, what the Constitution is might be more than just the document itself. So I think the best conception of the natural law tradition accepts the source thesis, but then adds a claim about what the focal case of law is, which is that law provides reasons for people to follow it. And one of those reasons, there's other reasons as well, is that it has to come from a person or entity with the authority to care for the common good. And it seems like that's something that the document wouldn't be able to tell us. And so if that train of thought is right, then it seems like what the Constitution is, at least from the natural lawyer perspective, isn't just what one can put in their pocket.
So
first of all, we want to be careful to distinguish the claims that we are making about the Constitution's ontology from the Constitution's status as law. Knapp's initial claim in his book is not a jurisprudential claim. He later develops one in the context of some of his more recent work, but his primary ontological claims relate to the nature of the Constitution, not the nature of law. That being said, what we hope to have documented in terms of discursive use of the Constitution, conceptions of the Constitution, both prior to ratification and post-ratification, are, I think, consistent with basically Harshan premises about the nature of law. And, Will, if you want to make the further claim that we have not only documented that the Constitution has retained its ontology, but it has retained its status as law by drawing upon the evidence that we found, have at it. But we are very wary of conflating those two things because we think that GNAP has already done a good bit of that, and it's caused some confusion. With respect to the questions about the way forward and that whole section, yes, that is probably the least developed section of the paper and the most tentative. We did not want to make it appear as if we were relying upon controversial jurisprudential premises, but you have suggested reasons to think that we might have been implicitly doing so on the grounds that at least one of the authors is basically Hardian in orientation, and it might have come through in that section.
One of them is not.
Yeah. But I do want to clarify one thing about what we are proposing in our little experimental jurisprudence projects. We're talking about ordinary people. We are not talking about public officials in that discussion. So, if we were strict Harshans about this, we wouldn't care one way or the other about what ordinary people thought about what the law was, or specifically here, what the Constitution was. But here, because of the legitimacy problem that we're concerned about, we're focused on ordinary people.
Okay.
Do you want to address the
Well, just kind of specifically on that point, we got these social facts about how people talk about the Constitution, and just the fact that ordinary people that think the Constitution is very old. Okay, I mean that's really, I think, the social fact about how ordinary people understand officials when they take the oath. Okay. So the social facts of current language conventions and use of the term the Constitution, those tell us what the oath means as a promise, okay? So I don't think I've presupposed anything about the nature of law when I talk about that. So I don't think we're presupposing a specifically jurisprudential claim. We're not opposed to having these claims about law be true. Constitution says it's law. I mean, we're fine. I mean, I'm fine with, maybe it's right, okay, and maybe it's right in virtue of fitting the natural law, serving the common good, blah 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 blah. Or maybe it's purely social facts would be enough for that. But it's the nature of the moral obligation of the promise that really has the normative kick for me.
I'm prepared to concede completely that a natural lawyer could not just unequivocally endorse the proposition that a written text just is law, but that's not the claim that we are making. We're making a claim about what the Constitution is, not what the law is. And a natural lawyer could say that the Constitution is a text without saying that the law is a text.
But I do think he makes really important contributions that I don't think you fully undermined. To me, I don't read his argument as being primarily grounded in philosophy or linguistic theory or that sort of thing. It's primarily a historical argument. He's a historian. And the argument is that at the time of the framing, the Americans just didn't understand, or they didn't share an understanding of the Constitution as exclusively a written text. And I think that argument needs to be rebutted on its own terms, not by criticizing radical linguistic theory and philosophy or something, and not by reference to the Constitution's text, because that's just circular. Yes, maybe the text of the Constitution contemplates that the text of the Constitution alone is America's Constitution, but the question is whether the framing generation agreed with that, and to the extent that they did not contemplate the exclusivity or even primacy of the text, then the fact that the text itself claims exclusivity doesn't really get us where we need to go. So to me, the part of your paper that most directly refutes Skienap's core argument is the part, it's 3B, where you're showing lots and lots of examples of the framers using the words "the Constitution" to refer specifically to this document, both at the state and federal level. But I'm not sure that's entirely responsive to Skienap either, because one might well understand that there is a document called the Constitution that has a very important role to play in describing our higher law without necessarily believing that that document is the sum total of the higher law, or that the process of ascertaining the higher law must necessarily be limited to efforts to ascertain the meaning of the words and phrases in that document. You've got a lot of good stuff laying out, writings of St. George Tucker, Patterson, Marshall, others who come close to viewing the American Constitution in those terms, but mostly that's material from the 1790s and early 1800s. And Skienap agrees that in the 1790s, the modern notion of this written constitutionalism emerges and ultimately becomes, dominant, if not even universal. His point is that at the time of the framing itself, that understanding had not taken hold, certainly not universally. And then he says that might cast some doubt on the originalist enterprise. So I think to me, the most interesting question for originalists is why should it matter? It's not clear to me that for most originalist theories, Skienap's thesis, even if it's true, really matters that much at all. I think Will kind of through ways in which it might. But I would love to see you guys explore that more. So one, really come at him at the historical evidence, because he's trying to say there's no consensus. And I think muddying the water doesn't get you where you need to go. And then two, I'd love a theoretical explanation of why it actually matters for originalism if he is right.
Thanks. So I'd like to see a little bit more about particular arguments that he's making, and I think you can free up some space by dropping the radical indeterminacy stuff into a footnote and the positivism stuff into a footnote. By positivism, he just means law comes from enacted text, so he's not disagreeing with you there. And the stuff that you could add could include a lot of his recent work on social contract theory, which I think really nicely illustrates the way he's thinking about the nature of the problem. Also, the material that he has about the debates in the first Congress about how to do amendments and whether the amendments should be textually incorporated, which I think if that had happened would have made the indexicals argument much trickier. And so working through how that works, I think, might be interesting for your readers. And then I think the core of some of his claims just needs to be better fleshed out and responded to. So jumping off of what Bernie and Tom were saying, it seems to me like he's saying, look, there is a written constitution, sure, people know how to refer to that as a document, but the fundamental law, which is also referred to as the Constitution, is partially constituted by the text. So each state gets 2 senators. That's a textually constituted aspect of our fundamental law. It's partially non-textually constituted, but is referred to in the Constitution. And that's very familiar for everybody in the English tradition, where there's a notion that the text is reaffirming or clarifying aspects of the common law, but it's not actually creating the law. And then there are aspects of fundamental law that are not textually referred to. And, we see some references to that in the text itself, like the Ninth Amendment. And so his view is, look, the text itself, when you're an English constitutionalist, which the Americans were, is not going to naturally be read as a sort of integrated document. It's going to be read as part of a broader experience of reading texts in the customary constitutional tradition, where some aspects of the fundamental law are textually constituted, sure, but only some of those aspects, and so the system is just going to be viewed in much more dynamic terms. And I don't get a sense from the paper that you're grappling with that set of arguments, which I think is at the core of what he's saying. And thinking about it in terms of the social contract and fundamental law coming from the social contract, not just from the written text of the Constitution, I think would be a nice way of engaging with that argument.
Steve?
Well, actually, I had a couple questions, but they're similar to the ones that Judd and Tom have just been raising. So one of those, maybe I won't. I'll just, in case this is, these are just requests for clarification, or maybe you've answered. Is there any reason to think that there could not be, at the same time, call it the amorphous constitution, or, the unwritten or sociological or whatever you want to, and the textual constitution that can be carried in. Is there any use? I kind of read you as implying that if you have the one, that kind of displaces the other, and I think some of these questions, is there any reason to think that that would be true? Why that would need to be true, so that then you just look at the context when references to the Constitution. Sometimes it would refer to the document, sometimes it might refer to something more broadly and so forth. Is there any reason why that couldn't be true? I guess the other one is, even if you think the written Constitution displaces everything else, the one you carry in your pocket, in a sense it displaces everything else, and it is the American Constitution, it still has to be referring to something outside itself, right? I mean, otherwise it would just sort of collapse into nothingness. It's language that's referring to something. And does your argument tell us anything about what it is, whether it's referring to public meaning, or whether it's referring to intentions, or whether it's referring to principles of some kind, or something of that sort? Both of those, I think, would be ways of getting the broader unwritten Constitution back into the picture. You say either it's still there along with the written Constitution, or the written Constitution is there but it doesn't make any sense except by referencing something outside itself, which might be this other thing. And those are I'm just trying to get clear on what your claim is, and what its significance might be for these kinds of questions.
First of all, I think that we should clarify in response to Tom's and a number of questions that have been raised both during these sessions and outside of these sessions. We do not think that GNAP is a radical indeterminist. We do think that he invokes philosophers who can be read as radical indeterminists, and some of his language can be read that way. What we do is, in the first section, talk about why ultimately we think he's not best read that way, that we can adjudicate the historical dispute that we have with him on the merits, and that we can do so without worrying about whether Brandom's theory of Hegelian reciprocal recognition is something that is coherent at all. So in our defense, we didn't start this battle, he did. He invokes these people, and we want to confront the arguments that they make on their terms so we can understand what he's arguing. And what we take him to be arguing, and this goes to the point about, let's step back a second. Positivism, the discussion of positivism. We think that his discussion of positivism, and specifically his conflation of positivism with commitment to textualism, with commitment to written text, invites a ton of confusion, because it leads him to do things like argue that because the framers weren't positivists, they weren't textualists, and because they weren't textualists, then we couldn't have a written constitution at the founding. And it's not standard within jurisprudence to conflate positivism with textualism. The claims that we are making about what the Constitution is do not turn upon the nature of law, and we think that it's important to sort out that confusion so we can focus on the core debate that we have with him, which is what we understand to be the question of what the Constitution is.
And what? So a couple of additional points in terms of is there any kind of integration integration clause indicating that this is the entire agreement? Well, there's not anything saying that this Constitution is the entire agreement, but there is a binding commitment by every single office holder today that this Constitution is binding. There might be some other stuff that's binding for other reasons, but this Constitution, that's the one that we're bound by oath. So figuring out what that one is job one for figuring out the moral obligations of current office holders, I think. And yeah, there might be a lot of unwritten law, unwritten customs, behaving in various kind of un-American ways is not good. There's a lot of really good customs. There's some bad customs, okay. But again, it's the oath, it's this Constitution. I did want to, so one possible plan, we've been planning this for years, kind of provoked by the July piece that just came out. In terms of his bit about Madison initially suggesting inserting stuff, I'm taken by the relationship of the, I think there's a good analogy between kind of two different ways of doing the Constitution, one with, a bunch of amendments at the end, one with interspersing, and the relationship of the statutes at large with the U.S. Code. So, as Will has pointed out many times, fun fact, the U.S. Code is not actually the binding form of statutes. It's the statutes at large. So if they goof up when they codify things in the U.S. Code, that doesn't change what the law is. But people don't have any, so the U.S. Code, right, is this long series. When we change the U.S. Code at particular times, we insert stuff the way Madison suggested we should do. But nobody has any problem looking at that and saying, well, that part was inserted at a particular time. We have to understand Title VII the way those words express things in 1964. We have to understand Title IX in terms of this other time. That suggests to me that even if Madison had won, there would not be any sort of we're re-speaking the entire Constitution when we adopt an amendment sort of view. It's possible to just put it all together in an edited form and still think of the different parts as authored at the time they're actually authored. So that was, when I read that years ago, I thought, the analogy between the statutes at large and the U.S. Code would be one way to deal with that. There's a lot more evidence we could dig into. It'd be great if we could, trawling through the. We just search for the phrase "copy of the Constitution" in Founders Online. The newspaper databases would be great. See what normal people were noticing. Payne has this description of popular culture, saying everybody was just taking a copy of the Pennsylvania Constitution out of their pockets and talking about it that way. And he's a famously unreliable narrator, but he, Americans did have a conception of themselves as being really new and different. I don't know how much of it was noticed. The thing that matters is what the thing actually is, though, not what people noticed.
Very well said.
Yeah, I just wanted to sort of add my voice to Judd's point that I think that it would be better to just remove the part about indeterminacy because, Wittgenstein and Quine, there are a lot of different interpretations of their work, but, I don't think that the main reading is one of indeterminacy, and that it seems to me something of a stretch to, sort of argue that Jonathan might be making that reading and then rebut it. So it felt a little bit like a straw man, unlike some of the other parts of the argument, as I think, I would agree with Judd and Tom's points about that.
Yeah, given that he's disavowed it, it has served its purpose of being in the draft. So we put it in the draft, he disavows it, we take it out, and okay, we can all agree it's possible for words to have meanings.
He has expressly disavowed it to me.
I got to get that in writing.
I have it in writing.
Publicly.
I have it, but I'm not going to. Mike said there is some precedent for the moderator throwing 2 cents in, so it's going to be me, and then David, and then Larry Solomon. I just want to say that the social facts, which you mentioned, are these. Georgia doesn't prohibit abortions, even though it wants to today. It will in June, but today it doesn't. And that has nothing to do with the Constitution and everything to do with constitutional law. Chicago can't ban handguns. In my opinion, that has nothing to do with the Constitution and everything to do with constitutional law. And I think both your response to Jonathan and his paper would be served, and frankly, I think the whole debate about originalism would be served by paying closer attention to the difference between the Constitution and constitutional law, because it turns out they take an oath to uphold constitutional law, not the Constitution, in practice, on the ground. Otherwise, Georgia would have abolished the right to abortion 30 years ago. They didn't abolish that not because of the Constitution, but because of constitutional law.
I think it's an omission, and it's a glaring omission, and that is any reference to the reference of our Constitution and the Declaration of Independence. This Constitution is for the United States of America. That's the first time it's used. The United States of America, we know from the text of that goes back to the Declaration. They say it's, and the Declaration says, the foreign to our Constitution and unacknowledged by our laws. So a Constitution made for a United States that already has a Constitution might be more complicated than you're suggesting. What our Constitution is in 1776 is obviously an interesting question, but at the very least, if your title is going to be our Constitution, my immediate thought was, okay, well, that's our Constitution, whatever that is, that's our Constitution, then we have a Constitution written for it. or for the United States that already had a constitution, which is different from the Articles, because the Articles comes later. I really like the distinction between ontological and epistemological. I kind of want to think that should be maybe the first thing, Section 1. It's really important, but it also reflects something that, Chris, I know you know is perhaps more prior, and that is, to what extent do I know anything except my own thoughts? If I only know my own thoughts, then epistemology and ontology are the same thing. And lastly, with respect to that, this may not be useful, but it's always the quote I bring up in this context, is the Blaisdell decision, which shows that the Supreme Court has at times rejected the notion of not indeterminacy, but they have been inaccessibility. So that we cannot insist that what the provisions of the Constitution meant to the vision of that day, it must mean to the vision of our time. So we don't interpret the Constitution, we interpret our visions. But it's not my individual vision, it's a temporal vision. I don't know, somehow within 20, 30 years, there's a coherence, but then it falls apart. I don't agree with that theory at all, but it is not, it is a very prominent theory, obviously has a majority on the Supreme Court in an unrepealed decision.
Love the paper. I do think you have a structural problem that, as many of the comments, including Bernie's and Tom's, indicate, there's sort of the part of GNAP that gets the most traction and is most central to what he's doing. And then there's the philosophical stuff in GNAP. So how you solve that structural problem, is difficult. You might consider separating this into two papers, because the philosophical work sort of takes quite a bit of setup and sort of detracts from the stuff you say that I think is answering the parts of GNAP that are most central to GNAP himself and to his reception. So for what it's worth. On the but I urge you not to drop the philosophical stuff, because these things GNAP has said about Brandom and Quine, they get picked up by other people and then repeated as gospel, right? And this stuff can't, I'm so grateful for this paper, because someone has to do the work necessary to show that GNAP's interpretation of Brandom and Quine is just, to the extent that he thinks it does any work for him, is just utterly wrong and insupportable. Certainly Brandom himself does not accept GNAP's interpretation of the implications of his work. And of course, we can't ask Quine, but I'm sure that he would reject the radical indeterminacy interpretation. Just a couple of other things there on Quine. I think it might be important to point out that in the legal context, the indeterminacy argument, which is really ought to be understood as an underdeterminacy argument, that's the way that Quine himself put it, is not made by Quine. It's made by Donald Davidson, right? It was Davidson, not Quine, who made that move. And then just another little Quine thing. You might want to take another look at Carnap on logical truth, because lots of people, including Tyler Burge, would say that the real argument made by Quine against the analytic synthetic distinction is not in two dogmas. It's in Carnap on logical truth. Just one more tiny itty-bitty little thing. Bernie, what you presented as the fixation thesis is not the fixation thesis. What you were talking about was the constraint principle. There is, however, a reason why people might make exactly that move after GNAP, which is that GNAP uses various forms of fixity and fixation in his book, but the way he is using it has nothing to do with the fixation thesis as I've advanced it. So that just generates a lot of confusion. I would just say that the constraint principle is not argued for on the basis that it was endorsed by the framers. And as I understand your ratification argument, I don't think that that would pose a serious problem to a democratic legitimacy argument, since it was clearly the constitutional text that went through the ratification process. Pauline Meyer's work about the sort of the particularities of the role of the text at various stages of ratification, including sort of intense popular scrutiny of the particularities of the text, would strongly suggest that even if there's other stuff that's part of the Constitution, that ratification was ratification of the constitutional text.
I had a lot of what has been said, echoes what I was going to say. I had trouble figuring out exactly what the target was in the paper. So if we put radical indeterminacy of language aside, if we assume we can communicate with each other, even if imperfectly, then there's that issue, which is an interesting philosophical issue. But if we just have to assume that we can communicate, and that we can communicate over time, that we can actually understand what our grandparents said, even if their worldview was different, and therefore some of the inferences that they would make in terms of connection with certain terms are different from ours, there's still a core that we can understand. So let's put that one aside. One thing that I wasn't clear about, putting the Constitution in one's pocket, I wasn't clear why the focus on writtenness is, a lot of people seem to think that writtenness is crucial. I was in Iceland once, and there's a rift in the middle of Iceland, a geologic rift, and that's where the law sayers went, and they would orally recite the law. Now, there are a lot of advantages to writing. One of it is, you can remember what the law is, but I'm not sure what would change if the Constitution was oral, if it was dated, if there was a certain date which the norms of the Constitution were announced. It's very convenient to have it in written form for obvious reasons, but norms are norms, and when they're announced by authorities, if my wife tells me to buy tomatoes at the grocery store, there's a norm there. And if she writes it down on a list, that's the same norm. So I don't quite understand the difference. The norm is the ontological point. How we understand it, the epistemology, of course, is different. And of course, the older the document, and if it's not in writing, it's particularly difficult to retrieve what the norm was. But it's still an epistemological issue, not an ontological one. The final thing is, and I think you're on board with this, I don't understand, the Constitution might not be law, despite what it says, right? And I'm not sure why if our rule of recognition is that this particular document is the fundamental law of the land, I'm not sure why it matters whether it was that became the rule of recognition in 1788 or whether it became the rule of recognition in 1800. But the Constitution could be not law today. That's a possibility, or it could be law alongside other things that are not in the written document. It could be as dead as the Confederate Constitution, but it would still have meaning. It would still retain the meaning that it had at the time the norms that were put in there were announced. So the paper goes over, you know, a number of these things, and I'm not sure what the proper focus is. I think the epistemological versus ontological distinction is a crucial one there. I don't think writtenness itself is crucial, and I think you know, the focusing more on why the argument doesn't depend upon what the current rule of recognition is, or when the current rule of recognition became the rule of recognition.
Okay, so I'll do last comment first. So I'm actually on the record as saying that I'm not sure whether the written Constitution is law, and I'm not sure whether it's actually important that it is. So I could hardly take the position that there's something about the Constitution that either demands that it be written or demands that it be law. The reason that we're focused on the writtenness is not because we don't think that it's possible to have, or that we think it's not actually the case that law is fundamentally about norms and not about text, but for the purpose of identifying precisely what it is that people are promising to follow and referring to when they refer to the Constitution. So it would be possible for that to just be a collection of non-textual norms that are out there. I mean, Steve Sachs has this great paper called Originalism Without Text that has a functioning legal society in which the law is entirely oral, and he asks, well, is that originalism? And, you know, we can debate whether originalism just is inherently the interpretation of a written text, but I think it's quite clear that what this society, which he calls Fredonia, is, has law. So there's nothing about our claim that either bakes into the notion of law some reference to text or anything like that. We just argue that as a contingent social fact, and one which, as you point out, and GNAP acknowledges, has existed since at least 1791, the Constitution, as people refer to it and talk about it, and to the extent that that's constitutive of language, what it means is a written text. It could be otherwise. We just argue that it's not otherwise. And I mean, to the further question of, okay, so what difference does any of this make? I'm not actually sure why GNAP thinks this makes a difference. I see him as engaging in a debunking enterprise about a founding myth that is said to have existed since the beginning, that we always had a written Constitution. But I'm actually not sure what he wants us to do with that today, because by his own acknowledgments, the written Constitution has been a focal point of discourse in politics ever since. Larry S., I don't want to cut the philosophical parts either for roughly the same reasons. Like, GNAP invokes these philosophers, and if originalists come off as like not being able to grapple with what he's saying about them, there's this suggestion that they're missing something really important about epistemology, ontology, and the philosophy of language, and I kind of just don't want him to get away with that.
So Wittgenstein has this metaphor. A lot of things I can't stand about Wittgenstein, but he has this beautiful little metaphor about the fly getting out of the bottle. So he says, okay, what do we need philosophy to, so the fly can get out of the bottle and be free and not be encumbered by this gobbledygook. So I kind of think of what we need to do with this philosophy is kind of, let people get out of this notion that you can't express things with language, and then prevent the fly from getting back in the bottle. Okay, so that's why you got to have people like Frege and Chalmers today. Just the kind of common sense debunking of the indeterminacy is because this indeterminacy stuff is afoot, and a lot of people are being confused by it. The jurisprudence stuff, I mean, there's a lot of people just getting a lot more confused about jurisprudence because this kind of claim has been getting a lot more traction. So as annoying as it is, I think it's important for that to be out there somewhere.
Yeah, thanks, Larry, for giving me an opportunity to clarify. I was not meaning to conflate fixation with democratic acceptation, but I was looking at a passage from the paper where it talks about the Constitution's nature becoming clear in the early republic, and to me, what that suggested, and what also some of Jonathan's books suggest, is that fixation kind of occurs at a moment after the founding, but then following on Pauline Maier or all of these other sort of views about ratification, then I wonder where the democratic legitimacy comes in. So to me, I feel like the conflict comes in where you have this idea that somehow the nature of the Constitution becomes fixed, say 10 years after the founding, and then the democratic moment is at ratification. So what does that conflict mean?
One thing, spatially, you can't have the kind of ratification we have without it being textual. I mean, you could imagine a hypo where like everybody's got these closed circuit TV cameras, and everybody is kind of just the elders are distributed among the states and all just speaking stuff, and it's just all being recorded, and nobody writes it down in a text. Steve's examples of that possibly being something like originalism, I think are okay. But in order for our Constitution, the same Constitution, to be ratified in one state and then also ratified in another, the only way you can do it is with a text. And before you have a printing press, you can't really imagine. You still have text. I mean, Magna Carta is a text, but dang it, it's not going to be discussed by everybody in England the same week when you have those technological limits. Eric's wrong, of course, but he needs, what he needs is the Copernican revolution. You have to understand, what revolves around what. The Supreme Court revolves around the Constitution, not the other way around.
So I concur in those who suggested that the papers should be split up. But I was really wondering about exactly what you thought the relation if they were kept in. So let's assume you're all right about Madison. They all thought of the Constitution in the way you did, and they think of the determinacy as possible. But you're wrong about language does turn out to be more indeterminate than they thought it would be, maybe even radically indeterminate. What difference should that make? Should we just continue with the Constitution as if we take their assumptions about the nature of language, or do we import our own? And that's just a general issue I have struggled with about assumptions that are wrong, and this is a very fundamental one. And I think it's raised in some sense because of these two parts of the paper, and yet is unexplored. Indeed, sometimes I found it very unclear what the relation was, and even if you do publish them separately, I think you probably want to talk a bit about the relations between the parts.
I agree. I really liked the paper. I thought it was really good and made a ton of sense. I agree that Genep's, it seems like his critique is more a historical critique than anything else. He's a historian. I mean, I'm wondering if there's like a general law problem or a general law angle to Genep's point, that there's a view that the Constitution relies on general law or common law backdrops in places, and that what he's doing is conflating the founders' views about general law's interaction with the written Constitution with the Constitution itself. And then this plays into, I think, Genep's part of the Federalist Constitution project, which is, I guess, maybe set off against something like a Jeffersonian view of the Constitution, that it's a strictly limited contractarian document that's very skeptical of general law or common law backdrops. And so the fundamental nature of the Constitution as a written document wasn't in dispute as much as the role of unwritten law or general law in the background, and that he is basically conflating that debate, whether the Constitution is something like a super statute that incorporates a lot of general law by reference, and that general law is part of, sort of interacts with the Constitution with a view that it's a strictly four corners contractarian document, which doesn't change, what this document is, that it's the written thing, but that is there unwritten law that interacts with it general law that interacts with it versus it being a strictly contractarian document, and what you all think about if he's conflating that and if there's kind of a general law explanation for the unwritten parts of the Constitution that he identifies.
So, what do we do if the radical indeterminacy is right? So you can have a view about constitutional truth makers, even if you don't end up having that constitutional truth maker. So the view about the constitutional truth maker is what you would have to refer to if a constitutional claim were true. So you can have an idea, well, the Constitution, all of the Constitution's requirements are requirements of meaning expressed at a particular point in time. If it turns out, because Quine is right, that actually never happens, okay, never happens, italicized, underline, boldface, then just all constitutional claims are false. So if you're a judge and you're going to say the Constitution requires blah, 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 the Constitution is like talking about the present King of France. It's just not there. And you can have a view about constitutional truth makers, about what would have to exist in order for the constitutional claim to be true. Okay, just all of the claims are false. And then I had something to say about the other point.
Just to follow up on that really quickly, I don't think that there's any compelling requirement that our constitutional decision-making be tethered to even the best, most correct theory of language or ontology. However, to the extent that it turned out that the Constitution, because Quine is right, isn't any particular thing and all claims about the Constitution are false, we'd have a pretty serious democratic problem, I think. And we would have to think very seriously about how to manage that in ways that originalism just might not be able to provide the answers for how to address.
Yeah. And in terms of how should we think about unwritten law? U.S. v. Fisher, I think, is the guide. So in cases where it's unclear, you make an assumption that the Constitution is not overthrowing fundamental principles of how government's supposed to act. So there's all this stuff that Marshall gives us in 1805 about talking about principles of right and wrong, lots and lots of ethics there as a defeasible guide to what the Constitution expressed in cases where it's unclear. So it's got to be defeasible, but yeah, there's lots of ethics. So I think the modern view of don't tell me, I don't want to say anything at all about right and wrong. Yeah, that's not right. Fisher has the right attitude.
And Adam, I think that you may be onto something about the conflation between the claim that there is this general law of which the Constitution is a part but not the whole, with the question of what the Constitution itself is. And that's something that we should probably press further on in subsequent drafts.
Okay, thanks.